Noel is going to talk to us about pensions cases, non-pensions cases that pensions lawyers should know about. Over to you, Andrew.
In light of the Avon decision, I did think about putting up a slide that just said all of contract law and all of public law, including the bits that definitely don't count. But instead, Naomi gave her talk about that, so I won't do that. Instead, I'm going to take some focus on 3 cases from within about the last 6 months. I'm going to start with the subject of privilege, and this builds on the talk I gave at the APL annual conference in November on privilege cases that we should all know about. I do a lot of professional negligence work, both in and outside of a pensions context, and civil fraud work. So piercing privilege and protecting and attacking privilege can be really, really helpful. My first case on my first slide is Al Sadek and Deckert from the Court of Appeal at the beginning of this year, January of this year. There are all sorts of really interesting privilege points in this case. It looks again at 3 Rivers number 5, the restrictive definition of client for the purposes of legal advice privilege. That doesn't bite in litigation privilege. Nonetheless, the court consider it and flag up once again that the Supreme Court really does need to look at 3 Rivers number 5. It is also authority for the proposition that legal advice privilege can apply to third parties. So about 10 years ago, Andrew Spink and I had a case called Phillips against Aon and Alliance Bernstein, a case about investment negligence in the pension scheme's context. One of the issues the trustees, our client, were thinking about was getting a funder involved, but they were worried about their privilege if and to the extent documents are shared with that funder. Well, we now know 10 years later from the Court of Appeal and Al Sadek, that's not a problem. But the most important aspect of this case is the so-called iniquity exception. Now, the facts of Al Sadek are pretty remarkable. They are allegations of kidnap, extraordinary rendition, unlawful detention, detention in solitary confinement, interrogation, all perpetrated by 2 Deckert partners when Mr. Al Sadek was in solitary confinement. Philip's laughing, not sure why. They are horrific allegations nonetheless. Those are the allegations made. Put shortly, it was said that 2 of these Deckert partners, Mr. Neil Gerard, who's had a lot of airtime in judgments recently, and another one of his partners were prepared to and did violate Mr. Al Sadek's rights. Lord Justice Popwell starts with an uncontroversial reminder about when the iniquity exception applies. He says privilege does not exist if the document comes into existence in relation to a crime, fraud, or other iniquity. And iniquity is a widely framed word. It is not just about criminal misconduct. It may be an absence of good faith, something that's underhand or contrary to public policy or the interests of justice. And on the next slide, you'll see that what he goes through in his judgment is all the authorities from the last few years looking at the iniquity exception. And these are worth a read when you have a case to grapple with, because the language in them is fantastic. I think it's Cox and Railton that talks about wickedness being at the heart of the iniquity exception. I told my 8-year-old daughter about that 2 days ago, and she asked me to leave her room so she could go to sleep. But nonetheless, the cases are worth looking at. The juridical basis for the iniquity exception to bite is that a necessary ingredient of legal professional privilege is confidence. And it's the absence of confidence because it is perpetrating iniquity, which means that the iniquity exception bites. Privilege has never existed. You're not piercing privilege. The document was never privileged in the first place. And on the next slide, you'll see that Lord Justice Popwell describes the touchstone of the iniquity exception in these terms. Amusingly, he does this by reference to a first instance judgment. He says the best case, looking at the touchstone iniquity, is the 2014 decision in the JSC Bank of the Abliazov judgment, 2014 first instance judgment. It happens to be his judgment where he looked at this. And he explains the touchstone, he was distinguishing such cases from those where exception applied to where the iniquity puts the conduct outside the normal scope of such professional engagement, or is an abuse of the relationship which falls in the ordinary course of such engagement. So the deception of a solicitor is at the heart of the iniquity exception, at least in some cases. And the next slide shows that the backdrop to this is there are competing public policy considerations. Legal professional privilege should be protected. Nonetheless, in the context of litigation, it's imperative that disputes are determined fairly and correctly. If evidence, proper evidence, i.e. non-privileged evidence, is concealed, that risks the proper administration of justice. So there were 2 questions, thank you, that the court had to grapple with in this case. The first one was, well, what's required for the evidential standard for the establishment of the iniquity, the so-called merits threshold. And the second one being, what is the legal test for the relationship between the communication and the iniquity to bring the exception into play? As to the first question, Lord Justice Popper said there was save in exceptional circumstances. And he doesn't explain at all what those exceptional circumstances are. He just gives himself a court of appeal, get out of jail free card. He says, save in those circumstances. The test is the balance of probabilities. The existence of the iniquity must be more likely than not on the material available to the decision maker. So whether that's a party doing their own disclosure exercise or any of us as lawyers trying to determine whether we can assert privilege or the iniquity exception applies. As to the second test on the next slide, he says that the relationship between the communication and the iniquity must be established. Is that there is no privilege in documents and communications brought into existence as part of or in furtherance of the iniquity. So those are two separate tests. So he says, suppose that Decker held a document which recorded information about unlawful conditions in which Mr. Al-Sadek was being or had been held. He said, first, if that information came to contain simply as an incidental consequence of their instruction, it would be part of Decker being used as an innocent tool in the fraud, the iniquity being perpetrated. In those circumstances, that document in Decker's possession is not privileged and would have to be disclosed. If, on the other hand, someone in RAC had gone to Decker and said, well, we're a bit worried about our detention of Mr. Al-Sadek. Can you look at what we've done and advise us on whether this is unlawful? That would be a privileged document because that is part of the normal professional engagement of the solicitor. So why, you might ask, is this going to be relevant at all to pensions cases? Well, of course, it was relevant almost exactly 10 years ago to the day when Burgess Salmon instructed Richard Hitchcock, who's not here today, against Nick Stillwell, who is here today, in the Desmond's matter that went all the way to the upper tribunal. That was a case all about whether the MVL loophole for Section 75 debts in Northern Ireland could be exploited by Desmond's, rather, not exploited, that's the wrong word, could be used by the Desmonds to reduce the Section 75 debt in the way that they did. They reduced their liability by about £10 million. The scheme was left with a £10 million deficit, but completely lawfully. But the argument did turn on whether the iniquity exception applied or not. So we've already seen it bite in a pensions context in TPR claims. And I think, not least on the back of the Bywater case that Nick and I were in last summer, we may see iniquity type arguments being raised again in pension schemes context with distressed employers. I think it's something to look out for. In terms of the red flags for it, the best example I think that exists is from the Peard in Nigeria case, Robin Knowles' judgment from the back end of last year, where there was this indecent turnover of solicitors and counsel coming on and off the record. And it became obvious, it seems to me, from the outside that something was going on. Well, what was going on was that solicitors were coming onto the record and saying, we're not sure about these documents. We think maybe they need to be disclosed. The client was saying no and firing the solicitors until Quinn Emanuel got a hold of the case and said, you really do have to disclose these documents. So that was my first case as a starter for 10. My second case keeps us in the Middle East, but moves us a little way around the Persian Gulf to Kuwait. And this is the Public Institution for Social Security and Al Wazan and the judgment of Mr. Justice Jacobs. I'm not cheating in this case because it isn't a pensions case, but PIFS, as it's known, operates the State of Kuwait's Social Security and Pension Scheme. And it brought a claim against Mr. Al-Rajan and a whole host of other intermediaries and organisations for secret commissions that have been paid to him between 1984 and 2014 in the sum of $874 million US. Certain of the PIFS applicants argued that there should be third-party disclosure made by various parties on the basis that they have practical control. So this is a classic thing we regularly see in pensions, professional negligence cases, where you are acting for solicitor X or scheme Y, and they engaged a particular consultancy for 20 years earlier on. And you say, well, hold on a minute, do they hold any documents? To what extent have you gone after those documents? Do they hold your documents, or do they hold their working papers? What have you done? What have you done about it to see? There were both state defendants, emanations of the state, and private entities in this case. And some of the private entities that might be relevant in our context were KPMG and EY. And the core of the applicant's argument was that documents had been obtained by PIFs in the past, and the court could readily conclude that the arrangement continued. So therefore, they were within their control, they should be sought. Now, what PIFs argued, unsurprisingly, was that each third-party defendant had to be looked at separately. They were different entities, they were different organisations. Whether there was any right to those documents at all was an individual matter. Mr. Justice Jacobs rejected the application, but in doing so, he gives us a really helpful judgment on the issue of third-party control when we're defending professional negligence claims or bringing professional negligence claims. He says, well, there's been this really interesting run of recent first instance authorities on third-party control. He looks at Lawley financing, some of those other cases. And the case he cites is the decision of Mr. Peter MacDonald Eggers KC in the various air finance leasing companies case. Control for the purposes of third parties to litigation is not simply about whether they have the documents and will give them over on some occasions. It has to be more than that. And he stresses real caution must be exercised when looking at whether applicants can get hold of third-party documents at all. But perhaps more importantly still, in this case, he looks on the facts at KPMG and EY. And what I put on the slide is a part of the order that the third party sought. They wanted an order that PIFs shall 7.1 search for and disclose documents held by KPMG by the 1st of March 2024 to include the following document. And the judge said, oh, come on, like, look at your own order. It reveals the fact that this is absurd. How can I order the PIFs defendants to search KPMG's files? Are you suggesting that I have to give them permission to go in and have carte blanche over everything KPMG have ever done and search them as they see fit? The judge said the order alone illustrates the fact that this is not a well-founded application. He then goes on in a much more traditional way to look at the terms of the retainer, to say, well, hold on a minute. These are simple third-party consultancies providing services. Their working papers belong to them. And he reminds us of the 1941 decision in Leicestershire County Council, Michael Faraday, that the working papers of a third party are not within the control of a party to litigation. So this case, I think, does two things that we should be mindful of going forward as pensions lawyers. One, it reminds us of a useful distillation, provides us with a useful distillation of the principles of control, of when it will apply, of how we should go about seeking such documents. And secondly, perhaps a little bit unfairly, it reminds us to think carefully about how we draft our orders. Because it seems to me quite often the drafting of the order takes place really quite late in the process of litigation. There were 6 silks and 8 junior counsel instructed on this application. If any of them had read the order and thought about that, just stepped back from it and thought, is the judge going to order that I have to give carte blanche access to KPMG and EY's files? I think I said, no, he's not going to do that. But the order, I assume, came so late in the process that no one really did that further test. So I'll take 2 points. It's brilliant on control on third-party orders as a useful reminder or a warning, perhaps particularly for counsel, on thinking carefully about your order. And that brings me to my third and final case. Now, I understand it's a free bar, so I'm willing to buy a drink for anyone who can tell me what case I am going to talk about by reference to these 2 pictures. And Andrew Spink has said he'll buy you dinner if you can identify the property on the left-hand side. Anybody? We're quite close. Well, not that close, but we're closer than London, closer than the Middle East. This is 9. Beth Grace is still. Beth, who is Welsh, was helping me with this on the train. This is 9 Gidderfalog Terrace, Penny Darren, Merthyr Tydfil. The house on the left was purchased for £65,000 in 2015. Anybody? By Mr. Churchill. The house, and I got very distracted on Rightmove 2 nights ago looking at this house, has some land adjoining it out the back. This is actually the view out the front garden, rather lovely. Out the back of the house, there is adjoining land owned by the council. And on the next slide, you'll see that Japanese knotweed encroached from the council's land onto Mr. Churchill's property. And this case has been all the way to the Court of Appeal because it deals with compulsory or the possibility of compulsory ADR. Mr. Churchill sends a letter of claim in 2016 saying, well, hold on, Japanese knotweed has encroached on my land, you need to do something about this. The council responded and said, how dare you? How dare you write to us through solicitors rather than using our corporate complaints procedure? You must do that. They said, if you don't use our corporate complaints procedure, we're going to bring an application for a stay and we're going to seek our costs because this is obviously unreasonable conduct. Deputy District Judge Kempton Rees dismissed that application, and he dismissed it on the basis of the well-known Halsey judgment from Lord Justice Dyson back in 2004. Lord Justice Dyson said, well, you can't force parties to engage in ADR. That'd be a breach of their Article 6 rights, and so on and so forth. This case then remarkably quickly gets elevated to a Court of Appeal bench consisting of Lady Carr, the Lady Chief Justice, the Master of the Rolls, Sir Geoffrey Voss, and Lord Justice Burt. And the question for the Court of Appeal was a short one. Can the court lawfully order the parties to court proceedings to engage in non-court-based dispute resolution process? And if so, in what circumstances should? There were a remarkable number of interveners in this case. The Law Society, the Bar Council, pretty much every other ADR organisation you can think of, about 13 of them intervened. And the submissions ultimately made by the Bar Council and by the Law Society was, well, actually, no, the court can order parties to engage in ADR, but only on the basis of 3 factors. That's if it did not impair the very essence of the claimant's Article 6 right to a fair trial, that the ADR was made in pursuit of a legitimate aim, and thirdly, that it was proportionate to achieving that legitimate aim. The Master of the Rolls had no doubt that ADR was and should be something that he can force the parties to engage in. He says it's extremely beneficial to parties to disputes, even when they're initially unwilling, can be successful. Some sort of mediation is generally cheaper and quicker than court-based resolution. But the devil, of course, was in the detail, because what the party said was, well, if we are going to say that we have to do that, when should we have to do that? What are the factors that need to be taken into account for the court to impose a stay and force the parties away from their Article 6 right to a trial? And the Bar Council made no less than identify no less than 11 factors that they said were relevant. So, for example, I won't go through them all, but number 1, the form of ADR being considered. And that seemed like a fair point to me on Mr. Churchill's basis. He's being forced into the council's corporate complaints procedure. There's no mechanism for costs. There's no written policy as to what's going to happen. It doesn't stop the limitation clock from ticking. And he has no idea what the timescale would be. These are the sorts of submissions made by the Bar Council. On the next slide, you'll see a whole more. And on the next slide, again, you'll see the final ones the Bar Council identified as being potentially relevant. But the Master of the Rolls gave this fairly short shrift. What the Master of the Rolls said is, I do not believe that the court can or should lay down fixed principles as to what would be relevant to determining those questions. He says it would be undesirable for judges to be given a checklist. Well, that's fine to an extent, but of course we all have experience of the Master of the Rolls, and some of his cases have surprised us in, for example, HR Trustees in Wembley, where he's gone a little bit rogue, it might be said. Checklists can be quite helpful, because then at least we know what we're advising our clients are going to be the relevant factors for the court to consider. But he wasn't going to do that, and he did not do that. So that leads me to my 3 final observations before I pass over to Silks almost back on time. The first one is that I think Churchill and Merthyr Tydfil does open up new possibilities for applying pressure, particularly in professional negligence claims. I think, how many times have I had claimants in pensions, prof neg claims, where the claimants are really keen to try and mediate early to get rid of the case, to get it done, perhaps because the funding position is good, or perhaps because they want to move to buyout as quickly as they can, or because they just don't want to engage in 4 years of hard-fought litigation with American consultancy. It seems to me here, you could go through the 11 factors identified by the Bar Council, explain to the judge how and why you satisfy all of them. And I think you're going to be pushing at more of an open door that ADR is something that should be ordered the parties to participate in. My second observation is by reference to CPR Rule 1.42E, and that's the court's duty to further the overriding objective by actively managing cases. I think I've already seen in one case judicial action that we would not have seen pre-Churchill, where judges are much more willing to force the parties towards ADR with a more aggressive timetable without undermining the timetable of going through the court process. And my third and perhaps more cynical observation as a barrister is that I think this will lead to satellite litigation. I think the problem with Master of the Rolls' judgment is that in Halsey, we had really clear authority from Lord Justice Dyson. If parties aren't going to do this, we're not going to force them to. Now we have, well, maybe we should force parties to if all these various factors are properly identified. So I think we could well end up with satellite litigation that we would have not seen pre the Churchill's judgment a couple of months ago. I'd be delighted to hear any observations or other cases people think are really interesting. Failing that, if you have any difficult questions, the Silks panel is about to start, and I know they are keen to have things that they haven't heard from. Thank you very much.
Thank you, Nick.